It is time to start the meeting. We've also formed a quorum. So I'm grateful to have the officials in attendance. We are seeing new faces, so let's introduce the public officers who are in attendance at today's meeting. We have Ms. Carol Yun, Deputy Secretary for Commerce and Economic Development. Mr. Raymond Wu, also from the same bureau. He is a Principal Assistant Secretary for Commerce and Economic Development. And Ms. Agnes Zhe from the DFJ, she's on the way. Members, basically we have to deal with 3 countries. Democratic Republic of the Congo, Liberia, as well as the Democratic People's Republic of Korea. We are talking about international obligations, so it doesn't have to require our approval. For today's meeting, we have only 2 hours. Generally speaking, we can't cover 3 countries. So do you have any preference as to the sequence? Or would you want us to deal with which one in particular? Should there be new points to be covered? Mr. Chairman, Madam Chairman, we don't actually have any preference. Well, in this case, we just follow the natural sequence. So DK Congo, Liberia, one regulation as well as the repeal regulation, as well as the DPRK. So first of all, paper CB bracket 1 720/12-13/01. It was issued on the 18th of March. Ms. Yun, would you like to walk us through very briefly? Yes, I will be brief, and then Mr. Wu will give you the background as well as the content. Thank you, Madam Chair, for inviting us to this meeting. According to the UN Sanctions Ordinance 5/537, the CE is required to make regulations to give effect to instructions from the Ministry of Foreign Affairs to implement sanctions designed by the Security Council of the United Nations. Madam Chair, you mentioned the UN Sanctions Democratic Republic of the Congo Regulation 2013. The background is that since year 2003, the UN Security Council has adopted several resolutions imposing and renewing sanctions against DR Congo. And they include a number of sanctions. This is because they are posing a danger to international peace, and therefore there is a need to extend the sanctions against DR Congo. In January this year, we received instructions from the MFA so that we have to implement the UN sanction resolution, UN Security Council resolution, and we understand that the UN sanctions Democratic Republic of Congo Regulation 2012 has already expired. The new one is similar to the 2012 regulation, which expired at midnight on the 30th of November 2012. The new one will also expire on the 1st of February 2014. So this is a new regulation to extend the original one. As to the background, as well as the trade relationship between Hong Kong and the Democratic Republic of the Congo, I'd like to defer to Mr. Wu. Thank you, Madam Chair. If I may briefly go through the provisions. Well, Congo is a country in Central Africa, and it became independent. And since 1996, it had been plagued by civil war and armed conflicts. In 2003, it signed a peace accord. But within DR Congo, there has still been a lot of violence. And therefore, since 2003, the UN has been imposing sanctions on DR Congo. Recently, in 2012, as a result of the Resolution 2008, certain sanctions have been imposed. and then they will come to an end on the 1st of February 2014. In January 2013, the CE received instructions from the MFA so that we have to follow the resolution 2078, and as a result, the regulation has been made. For this regulation 2013, well, as Ms. Yun has mentioned, mainly speaking, we followed what has been provided for under the UN Sanctions DR Congo Regulation 2012. The content is more or less the same. This is because we're mainly talking about an extension of the sanctions. When we look at the economic data, well, for the trade relationship between Hong Kong and DR Congo ranked 126 among Hong Kong's trading partners. The total trade volume was only 170.5 million Hong Kong dollars. It's mainly for the purpose of transit or re-export. The main form is telecommunications equipment. The volume is small, and also the nature is different because we're talking about arms sanctions. So I don't think that it is going to have a lot of impact on the economy of Hong Kong. Thank you. All right, in this case, I would like to open the floor to members for questions. No questions at all? So I'll just put it on record. Well, in fact, we usually have an expiry date, and usually we have an automatic continuation. So sunset clause is nothing new. In regulations similar to this, we always have a sunset clause. The government has been doing it all the time, but it doesn't mean that the targets of the sanctions will not be getting ready to do anything on a massive scale in the light of the expiry of the regulation. So please find time to talk to Dr. Koh so that he won't be misleading the public, because the government has been used to having a sunset clause even for international obligations and even for the copyright ordinance. We do have a sunset clause, so please talk to the executive about this point. I've also seen that for the MFA, for the UNSCR, it was numbered 2078. It was in November last year that it was made, and then very quickly in January this year that we were given instructions. But it was only in the 18th of March that this was gazetted. I think it is something very similar, familiar to us as far as the procedure is concerned. How come that it's taken 2 months' time? Time and again, we've given an explanation. In the past few years, as the chair has already said, we have embarked on something similar in relation to UN sanctions. In the past few years, both the Policy Bureau and the DFJ have been streamlining the procedures, and for the DFJ, they in fact have a dedicated team to deal with the provisions. I think last time the Secretariat has also come up with some statistics. Over 95% of the UN sanctions regulations have been completed in, say, 3 months' time since receiving the drafting instructions. Generally speaking, we can keep within 3 months' time. Now, in this way, in this case, we completed the task in 2 months' time. So for legislative work, for it to be completed in 2 months' time, like issuing drafting instructions to the DFJ coming back with a draft, and then we have to go through all the relevant formalities. I think it is already a very quick process, as far as my experience can tell. Thank you, Madam Chair. Legal advisor. Legal advisor has helped us in the sense that she has looked at the regulation. I want to know whether this is different from the model versions. More or less the same. Instead of in the case of, they have used the word for. It's a matter of simplification. Would you like to point it out to us? Section 3, bracket 4, A, B, C, and D. So in the case of has now been replaced by the word for. And then H2, it used to say in the requirements. Now it says the requirement. There is no difficulty in the drafting. 9.2 and 10.2 are similar. For the rest, the amendments arise from the UNSCR 2078. Otherwise, the rest is the same. All right, members, in particular members from the legal profession, any questions about this form of drafting? Those coming from the legal profession. I think I'm the minority, and it seems that I'm discriminating you and asking you to take up the burden. Well, I note that the previous regulation expired on the 30th of November 2012. That's in relation to a piece of local legislation. And then it was only on the 28th of November 2012 that the UNSC endorsed the resolution 2078. When was it gazetted? March 2013. So there was a window period, right? Do I understand it correctly? For that gap, for the vacuum, how do we deal with it? What is the picture like concerning our trade with DR Congo? I think we know that it expired on the 30th of November. It was on the 28th of November the UNSC made clear decisions to extend these sanctions, but then we are not able to catch up as far as the local legislation is concerned. I want to know what happened in the interim. Thank you, Madam Chair. Well, normal trade, whether there is this regulation or not, will not be affected because the UN sanctions regulation would only ban certain types of goods being traded. Mainly speaking, we are talking about arms and weapons. Even in the absence of this regulation, we have other law like import and export ordinance as well as the strategic commodities ordinance. They're general in nature, not targeting at any particular country. If you want to import and export arms, you need to get a license. It is unavoidable that we have a gap in terms of the timing. But then for arms, I don't think there is any window so that people can move them in and out of Hong Kong freely. And then we had a trade volume of $100 million, and that's about telecommunications equipment. That's not been covered by the UN sanctions regulation.
My question relates to a matter of principle. Of course, we have our own legislation regulating arms and ammunitions. But for, say, financial services or financial assets for, we might provide financial assets to certain parties or individuals banned by the UNSC. So if there is a vacuum period, has the administration talked with the CPG on how to handle the vacuum period? Now, as for financial sanctions, generally, the number of people involved is small. And in the SARG, we have other regulations on money laundering and also financing of terrorists. So that can also cover the financial ban activities. The UN sanctions are international obligations that have to be discharged by the Hong Kong. But we are not a member of the UN Security Council, and we have to act only upon receiving instructions from the FA. But then we have other regulations which can address problems like money laundering and financing of terrorists. So these pieces of regulations can help and cover the activities under the ban. We've been following up on UN sanctions within the LegCo for nearly 10 years. I must share with you some information about the past. In the members in the last 2 terms rightly pointed out that since we have regulations covering money laundering activities and also anti-terrorist activities, is there a need for the administration to draw up such a regulation without vetting by the LegCo? We have held many discussions in the matter, and then the administration said that because it's international obligation and we have to draw up the regulations to govern that. Now you are telling us the same point that we have raised in the past, because you are using our argument saying that we don't need to ask the administration to legislate on such regulations without going through the LegCo. Now we have facing this vacuum period, and you are telling us again that you have other regulations governing all these activities during the vacuum period. Mr. To, the administration, can you go back and think about it? I speak on behalf. You can only enforce a regulation when a regulation is there. So if there are sanctions which have expired, we can only rely on the crimes ordinance locally to enforce the law relating to these kind of activities. And then, well, we are talking about this vacuum period, and I know that this is something that the CRG cannot resolve alone. Please go back and talk to the CPG about it to tackle the problem of the vacuum period. Madam Chair, the vacuum period, is it because the CPG needs time to scrutinize the resolutions, or is it the case that the UN is thinking about not to continue with the relevant resolutions or not? Thank you, Mr. To. I think it's just a matter of procedure. We have to receive an instruction, and normally we would come up with the drafting instructions, and then the CFJ will come up with a draft, and then we need to do some internal circulation among the government departments, and we have to let the CPG have a sight of it too, and then we will go back to the normal route of queuing up for the Gazette. So, and we have to go through all the procedures before we come to the Gazette. So in the past few terms of LegCo, after suggestions made by the members, we can finish the entire process within 3 months after we receive the instruction from the CPG. Of course, there is still room for improvement, but taking into account the Hong Kong's existing judiciary or legislative process, I think we are doing it really fast already. Mr. To, my concern is a little bit different here. The sanctions involve people in Hong Kong who may have trade with parties in that country, and there are sanctions imposed on such activities. For some regions, they may not be very familiar to Hong Kong. And still there are people who might have trade relations with people in these unfamiliar places. So these places present business opportunities for some people in Hong Kong. And people might specialize in trading with these remote places. So I'm concerned that if we have a sanction or sanctions, and then there is this vacuum period, does it mean that actually there is no a vacuum period in the UN resolutions? So as policy-wise, would they be able, or would it be able to make an announcement earlier just to make it clear that the sanctions will continue? Actually, within the UN, there is no gap between one resolution and another. And we have the resolution, and then we have a sort of pre-announcement of the relevant policy, then people would be absolutely clear that there will be a continuation of the sanctions. So, even if you are not able to gazette the relevant regulation, can you make an announcement a little bit earlier to say that the government is proceeding with the regulation? Is it a more reasonable way of doing it, as the way I suggested? Actually, for a number of government policies, you are doing it in the way I suggested. Say for the order on restricting the milk powdered formula. So can you do it that way, so to minimize misunderstanding? Thank you, Madam Chair. Thank you, Mr. To, for your question. In implementing the UN sanctions, Hong Kong is not a member of the UN Security Council, and we must have the instructions from the MFA before we can proceed with the legislative process. So before that, we can't really implement the UNSCR. And what we can do is, once we receive the instructions from the MFA, we would amend the regulation as soon as we can to implement the UNSCR. Take the Congo as an example. Received instruction from the MFA in January. Since we are not a member of the UN Security Council, so in that interim period or vacuum period, we can't do anything in that period. Since we are not a member, Madam Chair suggested that we can communicate further with the mainland to see whether it's possible for us to get the instruction sooner from the MFA. If we are to discharge our obligations, you must have received the instructions from the MFA. Perhaps you have misunderstood me. What I'm saying is, now if the UNSC resolution is announced, and then that applies to all member states, and China is a member state, can say Hong Kong issue a statement saying that China is a member state. You don't even have to go into whether you have received the instructions or not. You can just issue this statement saying that based on experience in the past, we would be receiving instructions to implement the sanctions. So that would make it clear to Hong Kong people that the resolution is here to stay and it will not be removed. Okay, I would defer to the D of J colleague on the legislative part. as long as we haven't received any instructions from the MFA or CPG, we don't have the authority to implement the UN sanctions. We can't say 100% that MFA is definitely going to ask us to implement UNSCR 2078. I don't think it is appropriate for us to make an announcement prior to receiving the instructions. Would Mr. To suggested whether people would think that the resolution will be removed? And I don't think so, because people who are engaged, say, in the arms and ammunition industry, they are watching very closely the progress of the resolution. So they know very well the latest situation on the UN resolutions. Well, I believe what you said is true about arms and ammunition. But for other commodities like luxury goods, what about those? The sanctions are mostly related to arms and ammunition and related equipment. These are very specialized equipment, and they're running the risk of engaging in those trade activities, and they are committing a lot of resources into those kind of trade activities. And then they would not take the risk of, say, doing a trade in that sort of a vacuum period. Now, as for the financial sanctions, I understand that the Bank Association is following very closely on the latest situation on UNSCR, and they have a list themselves, and they are not relying on the Hong Kong government to implement the UN sanctions to decide on how they would deal with their customers. So I think the people are very careful. So I can just say that it is not appropriate for us to make an announcement prior to an instruction has been received from the MFA. Mr. Liao?
I was about to leave because there is a clash between two meetings. I think Mr. James To's question was very broad in nature, but then the answer given was more focused in terms of the local arrangements. I'm not an expert in international law, but then when the UN is to impose sanctions, there isn't any jurisdiction, so it has to count on domestic legislation before the UN sanctions can be implemented, and this is exactly what we are doing. I believe that for the UN to impose sanctions, and for that to be reflected in domestic legislature, there is bound to be a gap, a time lag. So please go back and talk to the International Law Division as well as the MFA. Or you can do some research on your own to see how best you can reduce the time gap. And then you can answer James To's question. We know that we need to wait for the MFA to issue instructions before we can start our work, because if we haven't got the marching order, there's no way we can do it. We aren't a sovereign state. But then China has also got the obligation to make sure that the UN sanctions will be practiced in every corner of its territory. So we have to do this as part of our duty. I don't think you can answer James' question. I can't answer the question. Probably you have to go back to find out the answer. That is how much time the UN would give in relation to the gap between introduction of the sanctions and the implementation of domestic legislation. Perhaps I can give an answer off the cuff. Yes, it requires domestic legislation to implement UN sanctions. We've looked at the examples of Australia and Singapore. Depending on the complexities of the sanctions involved, even they would need 2 to 3 weeks' time to introduce the domestic legislation. As Mr. James Toh has said, the UN sanctions per se do not have legal force within a particular country. Domestic legislation is required. Others are also subject to their own restrictions, but maybe they can do it more quickly because, after all, we are different and we have to wait for the marching order from the Central People's Government. I just want to know how much time do they give to the member states? Is there a time restriction? No. So it means that you can do it in 15 years' time. In theory, it is. But then you need to give regular reports. From time to time, you need to report on the progress of domestic legislation. So that would be used as a way to monitor it. Well, as Mr. Wu has said, money laundering and sale of arms, they are under adequate control, relying on other Hong Kong laws, but then not welcoming certain individuals into Hong Kong, even on transit purpose. That requires a specific piece of legislation to give it force. The Director of Immigration can, of course, exercise discretion. He has got a name list making reference to the UN sanctions to reject certain individuals from coming into Hong Kong. And this confirms what we have always been saying. We don't need specific legislation to implement the UN sanctions. We always disagree with the executive in this way. When we do introduce domestic legislation, it is not desirable to have a time gap. But then, it was only 2 days before the expiry of the previous resolution was the new resolution made. So there's nothing we can do to prevent a longer time gap. And we must also wait for an MFA instruction, because after all, this is diplomatic in nature. I hope that you can reflect our concern to the CPG. We find it undesirable to have a window period, because in the interim, we can only rely on our local legislation to impose the sanctions. And when it comes to the unwelcome guests, if we want to reject anybody from coming into Hong Kong, we have to rely on the powers of the Director of Immigration. So I hope everybody is clear about this point. Next, we can go through the clause-by-clause part of our work. But of course, we can cover it in chunks. So first of all, UN sanctions, DR Congo Regulation 2013. I think you can go by sections if there aren't any specific changes. If I may assist here, part 1 for the interpretations. A number of numbers have been removed, and they have been replaced by 2078. So this reference has been changed. Any questions? No. Then we move on to the second part. Part 2, the legal advisor has already referred to it. Section 3, subparagraph 4, you have a change or an improvement in the drafting. And then section 6, specified person. As far as the definition is concerned, the previous one containing a number of resolutions that has been taken away, and now it refers to resolution 2078. Section 7E, there is a condition. In fact, it is a relaxation. You may gain entry on this ground. This is to implement paragraph 10 of the Resolution 2078. Exactly. For people who used to be denied transit, I want to know whether there is a mechanism for the Hong Kong government to know what UN sanctions have been introduced to allow the Director of Immigration to know about it. I think this can be done because for people from DR Congo, they need a visa, and I'm sure the government is in possession of such information, and the visa application may be refused. Whether that person is a terrorist or not will certainly be a ground of consideration. What about transit? Even for transit, they need a visa? Yes, for people from such places, they need a visa. We've been given so much concession all the time that we don't know that even for transit, you may need a visa. Section 8, paragraph 2. Section 9, paragraph 2. Section 10, paragraph 2. They are all improvements in the drafting. Well, I need to explain to new members. We have got many new members here. Usually for cross-by-cross scrutiny, we won't be going so quickly. Generally speaking, we will be scrutinizing bits by bits. But then this is already the 4th term of the LegCo that we look at something similar. We have already got model regulations. So generally speaking, we have a change in the name of the country, and then that's why we can be so quick with the cross-by-cross. But I hope we are not giving you the wrong impression that for other bills you can do it in a similarly expeditious way. I understand. You have a template and it has been agreed. I do understand. Thank you for reminding me. Should there be any deviation from the template, then we need to take a fresh look. Say, for example, a new drafting style. Agnes, please continue. No change to part 4. Part 5, again, no change. Part 6, again, no change. Any questions? Let's continue. Part 7, no change. Legal advisor, any comments? Members, no specific views. All right. Part 8, Section 30. The CE's destination to correspond with the earlier changes. Other resolutions are not mentioned. We'll only mention Resolution 2078, paragraph 4. So paragraph 8. Paragraph A has been deleted. We've only got paragraph B being left behind. Any questions? No? Part 9, duration. So we have changed the date. This will expire at the midnight on the 1st of February 2014. All right, next time we'll watch out for any possible window period. All right, thank you. And that means we're finished with the UN sanctions, Democratic Republic of the Congo Regulation 2013. Now we turn to the 2 for Liberia. One is for repeal and the other is a new one. Ms. Yun, please. Thank you, Madam Chair. I'll be brief in the introduction. The UNSC, since year 2001, has been imposing a series of sanctions against Liberia, like arms and financial, etc. Well, it is still imposing a threat to the international peace and the security of the region. So Resolution 2079 has been made so as to extend the sanctions. In January 2013, we received MFA instructions so as to implement the UNSCR. When compared with the UN sanctions, Liberia Regulation 2012. They are quite similar. All the provisions except the financial sanctions have all been expired in 2012. But then the 2013 regulation includes financial sanctions. Therefore, the previous one does not need to be kept. And in fact, we have the UN Sanctions Liberia Regulation 2012 Repeal Regulation. It will be used to repeal it. And the new one will come to an end on the 11th of December 2013. Maybe my colleague and the DOJ representative can fill you with the background. Agnes, please. Or maybe Mr. Wu would like to give you the background. Yes, Mr. Wu, sorry. I will give you the background. It is on the west coast of Africa. It was founded in 1847. Well, it has got the second largest maritime registry of vessels in the world, but then has been suffering from civil wars, and it is posing a threat to the nearby countries. And therefore, we have had sanctions since 2001. But then with the new president in office, the logging sector as well as the diamond industry has been removed from the sanctions. 2079 Resolution 2079 have been imposed, lasting for 12 months, to be expired on the 11th of December 2013, covering a number of sanctions. We received the MFA instructions. On the 12th of March 2013, the Senior Council decided to introduce this regulation. For the trade, it ranks 175th among Hong Kong's trading partners. The total trade volume is only $21.6 million, mainly re-exports to Liberia. And they are the telecommunications items. It is small in amount and it's nothing to do with the arms, so I don't think it's going to pose any problem on our economy.
Anything to supplement? Have we looked at the draft? Do you find any problems with it? Well, the UNSC passed the resolution only on the 12th of December, when the expiry date falls on the 13th of December. So now let's take a look at the regulations. Let's go through section by section of the regulation. There are two changes in part 1. One is the commencement, section 1. So that has been changed to 22nd March 2013. The second change, we have replaced Resolution 2025 with 2079, i.e. the numbering of the latest resolution. So that's for part 1. Any question? As background information, can these sections commence before vetting, right? Do we need an incorporation process? I'm asking this out of ignorance. When we first dealt with these matters, we were also very naive, because the regulation was not enacted by the electrical, but rather the administrative arm. In 1998, when the provisional electrical was in place, and it passed the or it conferred the power to enact such pieces of legislation to the administration, so they can gazette the legislation. And actually, the regulation has already commenced operation. And then it's just that we were trying to fight for some sort of role for the electrical in such pieces of legislation which skipped the electrical process. So actually, the regulation took place on the day when it was gazetted. So that was the result of the decision of the Provisional Legislative Council. I think I've answered Mr. Leung's question. All right. Part 2, Section 4, subsection 4A, B, C, D, E. We've crossed out in the case of, and then we replace it with the word for. And that's a textual improvement. Part 2, Section 7. Paragraph 2, Resolution 1521. We did away with Resolution 2025 and we changed it to 2079. The next paragraph also, we have also replaced 2079 with, we have also replaced 2025 with 2079. So that's the late numbering of the latest resolution. If members don't have any questions, please go on. Part 3, Section 9, subsection 2. We crossed out refer to in subsection 1, these several words. Section 10, subsection 2, and Section 11, subsection 2, similar changes have been made. So it's a simplification of the drafting. Will that approach be taken in future legislation? Yes. Yes, we'll try to improve on the model text. No change in Part 4. If members don't have any questions, Part 5, no change in Part 5. Part 6, Part 7, no change. Any questions, members? Part 8, no change. Part 9, Section 33. We've changed A. And that's also because we are now using Resolution 2079 and not 2025. Any supplement from our legal advisor? And also the expiry date, yes, 11th of December 2013. That has also been changed. Questions, members? If not, then we are done with this Liberia regulation. The repeal regulation is relatively simple. It says that the regulation comes into operation on the 22nd of March 2013, and then the Regulation 2012 is repealed. The commencement date, is it the 22nd March 2013? Exactly when is that? Was that repealed? On the day before or simultaneously on the 22nd March 2013 when the new regulation comes into force? Yes, from midnight onwards it will be repealed, and then the other one will come into force in midnight as well. The CE signed it off on the 13th of March. Why is there a gap of 9 days? I'm asking this again out of ignorance. Why is that there is a 9-day gap? The EXCO would decide on Tuesday, and then the Friday following it will be gazetted. But there is a special case here because for this Liberia regulation, the 2012 regulation already expired now because that there is no time limit to the section on financial sanctions, And for the 2012 regulations, the financial sanctions are still valid. So since we have the new regulation 2013, which includes also the financial sanctions, we don't need the 2012 regulations anymore. But then for the financial sanctions, then they will not come into effect immediately. Now, for that 7-day time gap, we make use of that to do a gazetting during that period for the financial sanctions. So to provide for seamless handover, we would be using that 1 week's time to ensure that the financial sanctions are properly in place before the new 2013 regulation comes into force. And actually, for most of the regulations, the EXCO will make a decision on Tuesday, and the relevant provisions will be gazetted on the Friday following. Okay. Now we come to the United Sanctions. UN sanctions Democratic People's Republic of Korea. Ms. Yun, please. Since 2006, the UNSC has imposed sanctions against the DPRK, including arms ban, travel ban, and financial sanctions, because the DPRK has failed persistently to comply with its international obligations on non-proliferation of nuclear weapons, and it has adopted the UNSCR 1532 to extend the ban coverage. In February, CE receives an instruction from the MFA requesting the government to implement sanctions against the country under 2087. And then that the scope has been extended to cover the list of items, materials, equipment, goods, and technology related to ballistic missile programs. And that has to do with the reason that I just mentioned. As for the reasons of the sanctions, I defer to Mr. Wu and also Ms. Zhang. Madam Chair, the North Korea, or DPRK, it became a member of the UN in 1991, as it failed to discharge its obligations on non-proliferation of nuclear weapons. We have imposed sanctions against North Korea, and because they launched this satellite in 2012, so on January 2013, the UN has expanded the scope of sanctions and also designated more specified persons and specified entities in the travel ban and also financial sanctions. The UCE received the instruction from MFA in February to implement the relevant sanctions in Hong Kong, and we have made the amendment regulation subsequently. It ranks 94th as Hong Kong's trade partners with a total trade of $492 million. And most of the goods are exports, including machinery, meat products, and telecommunications products. Because the trade volume is not that big, and then the trade doesn't involve arms and related materials. So the expansion of the scope for sanctions will not have any significant effect on the economy of Hong Kong. Thank you, Madam Chair. Legal advisor, do you have anything to add? The legal advisor has taken a look at the text, and you don't find any problem, right? In Appendix 1, the list of addresses, some of them are Hong Kong addresses. So how do we deal with these companies? Just watch out for them to make sure that they will not export such products, right? The specified entities or specified persons, they are under financial sanctions. Now, under the regulation, actually, we're basically freezing their assets. Now, under the regulation, the CE can gazette the specified persons and whose assets will be frozen. And actually, we have already done that after the Gazetto. The Hong Kong MA has also taken note of this and has also communicated with the banks. When we're working on the anti-terrorist legislation, we talked about the rights of employees in these companies. And it is very difficult for the employees to know that the company's assets will be under the sanctions, and if a person unfortunately joins the company as a secretary or a security guard, and if the assets of the company is frozen, would the government be allowing pay to be dispersed to these employees before the assets are frozen? We didn't make detailed provisions in that regard. Well, let's assume that we are doing a freeze or dealing with the company. The employee may get their pay through auto pay from a bank, and the bank would not know that the employee knows about the nature of the business of the company. So the bank will give out the pay, and it has a defense in that case. Now, if in a company, the company says that it's not going to be paying you through auto pay, and then my bank account has been frozen, and it's impossible for me to give out the pay to you. But the CAP 537 doesn't deal with that kind of situation. So this is exactly the trouble caused by not letting the LegCo to vet the regulations. Of course, the administration would just copy the exact wordings from the UN resolution, and then you would just be freezing the assets of the companies as specified. But we are concerned that about the rights of the employees in these sort of companies. So while we worked on the anti-terrorist legislation earlier, we said that there should be a provision or a provision for exemption. Say if the employer owes a pay or other staff benefits to an employee, then it should pay out all these benefits to the employees before the freezing of the assets, so that the rights of the employees are well protected. I don't think we can deal with this kind of situation in this subcommittee, but perhaps we can tackle this later on. Perhaps the administration can go back and consider when you freeze the assets of a company, that may clash with the anti-terrorist legislation. Now, if the employer doesn't know that he has this kind of right, then, well, it's too bad. But then I would like the administration to prepare some paper on this front. And actually, in the past, we haven't seen any companies whose assets are frozen because of these kind of sanctions. There is no such example in the past. The targets are not are targeted at companies trading with North Korean companies, And in the anti-terrorist legislation, the name of this company might not have been put in that list, but then the same principle applies. The spirit of the anti-terrorist legislation is to ensure that the rights of the employees of the company concerned is not affected. Now, if we were given sight of this regulation earlier, we would have already included that principle in this latest regulation. Now you have already gazetted or enacted the regulation. There's no way that we can go back and include that kind of clause in the regulation. So I want the administration to look at the spirit as enshrined in the anti-terrorist legislation, and in the future, please incorporate that in future legislation or regulations as well.
Well, there are certain exemptions, like necessary expenses or obligations, or they can be given funds to engage in a legal action. So consideration has been given to necessary exemptions at the level of the UN Security Council. I think in relation to the labor interests of the companies who are the targets of the sanctions, I don't think we have seen any exemptions. Perhaps they haven't gone to that level. Now, for us to implement the UN sanctions, when we look at the targets as well as the exemptions, perhaps we can consider this point. But I'm afraid there isn't much room to maneuver, because if certain exemptions are desirable, usually they are already clearly spelled out. So probably we'll say them maybe under a particular contract, if the target company has to discharge its duty under a particular contract, and the employment contract being one of such, so the employee has to be paid, and so there will be an exemption. Well, I think this is my immediate response to what the chair has just raised. So finally, it depends on the exemptions provided under particular sanction. I think you are familiar with the arguments put forward by members from the previous two terms. International conventions are very broad in nature, but when it comes to domestic legislation, first of all, we have to see whether we need a specific regulation to do it. There was a lot of debate about that. Even when it comes to local legislation, I think we should be we should have a say about the specific provisions. At the UN, there isn't anyone representing the labor, and that's why they didn't go to the details like we did for the UNETMO. I think this is the first time that a particular company has been named in UN sanctions to freeze the assets. Yes, we need to honor our international obligations, but again, we're also accountable to local residents. While we honor our obligations, we don't want the funds to be made available to North Korea to fund arms acquisition. But at the same time, we want to protect our local labor. So I hope the Bureau can go back and reconsider this point. We do want to exercise a monitoring role. In future, when we see other sanctions, yes, it doesn't originate from us, but we want to urge the administration to give regard to local concerns, like in the case of UNETMO. Yes, we want to tackle the terrorists, but at the same time, we want to protect the rights of the local people. And I hope that the Secretariat will make sure that this is clearly minuted. Kenneth. just now you talk about labor interests. If I may share a point or two with you. Assuming that on the 31st of March, this came into operation. In other words, prior to the 31st of March this year, the assets haven't been frozen. So what about the employees' liability? If the contract says that the worker has to be paid on a monthly basis, so would you enable him to be paid up to 31st of March, or would exemption be given in such a way that, according to the spirit of contract, that he will legally be covered? Say, for example, the contractual relationship being dissolved, and then wage in lieu of notice be given, severance pay be given, etc. So there are different ways to interpret the exemption. If you say that you want to take care of the labor interests, that's the first point. Second point is that for this sanction to freeze the assets, my understanding is that at most you can freeze the assets in Hong Kong. If the scientist is in Switzerland, say for example having a bank account in Switzerland or a bank account in Australia, then I think they can still make use of the funds in such bank accounts to pay the workers' wages. Well, accounts in banks all over the world and funds deposited with financial institutions all over the world will still be covered because the freezing is worldwide. But if they're able to get funds, they should pay the workers. Of course, for a UN member, and if your bank account is opened in a UN member state, then it will be frozen. But I'm not sure. I don't know whether this happens or not. Maybe there is a bank account in a place which isn't a UN member. Maybe they can still withdraw money. This is the first time I joined this subcommittee, so I'm just asking some hypothetical questions. Kenneth, this is the first time that we see a Hong Kong company being named by the UN. Perhaps I didn't make myself clear. Other than labor rights and rights, what about the payable items? Say, for example, this company may be renting an office space, and then under the UNEPMO, of course, they may try to conspire and try to move the funds around. Maybe they are just making up excuses to make sure that they can have funds available to themselves. So I think the Policy Bureau must come up with a paper to tell us what happens when there is a Hong Kong company being named in the UN sanctions, and then the funds will be all frozen. I want to know about the administrative measures and whether they are in line with the spirit and principles in the UNEPMO, so that the payable items can still be honored. Yes, we can produce a paper. Kenneth, it isn't too complicated as far as the provisions are concerned, but then this is a policy issue. So for this UN sanctions, DPRK amendment regulation, there's an outstanding issue. So after filibustering, I think we should come back to this point. But it doesn't harm if we move on with the cross-by-cross scrutiny. So we can start the cross-by-cross. Again, our legal advisor. Anything wrong with the drafting? No? I'm holding on to the Chinese version. Yes. Agnes, please. Well, in fact, there are only two areas, 2 points, which see a change. Part 1 Interpretation. Specified items. For a specified item, 3 documents have been added. So L, M, and N have been added for the definition of specified item. That is the IAEA and the Security Council. We have added the 3 documents, and therefore the second amendment will take us to Section 32. In between, we haven't got any amendments. For those in between, they are the same as those we have already covered. So that takes us directly to Section 32, which sets out documents that you may inspect at the office of the Director General of the Trade and Industry Department. So we are adding the 3 documents. If the members of the public would like to know what is being covered by the 3 documents, so if they're interested, they can go to the TID to have a look. It is quite a thick document, so the 3 of them could not have been listed in the regulation itself. Legal advisor. I think they're the same as the model regulation, right? I think the Chinese version has been amended to tie in with the English version, because in the case of it's being substituted by 4. So corresponding changes to the Chinese version. Any questions? No, then that's it for this regulation. Under luxury goods in the schedule, it is still an empty one. All right, thank you very much. So finish with the UN Sanctions DPRK regulation. But we have finished with this batch of UN Sanctions regulations because we are concerned about the impact on local companies. There's no urgency. Just prepare a policy paper for us. You know that we are in the course of filibustering. So probably the next meeting won't be held until a month away. So we'll get the paper from the admin, and then we'll arrange for our next meeting. All right, thank you very much. Meeting adjourned. Thank you.